Next, I am going to present on mistake as to identity. So, mistake must be a vital operative mistake, that is, it must be a mistake of fact, which is a fundamental to the contract. To be operative, so as to render the contract void, the mistake must be the fact and not of law or opinion. The fact must be essential to agreement, so fundamental as to negative the agreement, and must be on the part of both the parties. Thus, when both the parties to an agreement are under a mistake as to a matter of fact. So, as mistake as to identity, that is, mistake as to identity occurs where one of the parties represents himself to be some person other than he really is. We can state that the particular case here, Jagannathan versus Sisi for state for India. A person called S, a brother of the plaintiff, represented himself as plaintiff and thereby induced a government agent to a contract with him. The court found that government agent was deceived by the conduct of the plaintiff and his brother as to person with whom he was dealing, held that there was no valid contract. The defendant's agent intended to contract only with S brother and not with S and knew this. The consent was prevented. It means that an offer which had meant for one person cannot be accepted by another. And next one is about mistake of identity caused by fraud. The following cases were the plaintiff received orders in writing from a fraudulent man called Blencarn. The order papers had a printed heading, Blencarn and Company, 37 Wood Street. There was a well-known and respectable firm named Blenkiron and Company in the same street. The plaintiff, believing that the order had come from this firm, sent a large number of handkerchiefs. Blencarn received the goods and disposed them off to the defendants, who acted in good faith. The plaintiff sued the defendants. It was held that there was no contract between the plaintiff and the Blencarn, and therefore he had no right to sell the goods. The plaintiff intended to contract with Blenkiron and Company, and consequently no contract could have arisen between Blencarn. Hence, the defendants, being in possession with a good title over such goods, were held liable for conversation. Then mistakes. Mistakes are of many types. There are three types of mistakes commonly discussed with are common mistake, mutual mistake, and unilateral mistake. So common mistake is this type of mistake occurs when both parties A and B make the same mistake. A and B perfectly understand each other and their respective intentions, but they are mistaken about some underlying and fundamental fact. They may both be ignorant of the fact that the thing which is subject matter of their contract does not exist or has ceased to exist. The real legal question posed in analyzing the effect of a common mistake and intent every other kind of mistake is one of offer and acceptance. Has there been a real correspondence of offer and acceptance? In other words, has an agreement been reached or not? As can be seen, where the issue is one common mistake, consent is not a dispute. What is contended is that because of a common error as to some fundamental fact, the agreement or consensus is nullified. Common mistakes normally occurred in varied situations, but the most prominent is the case where the subject matter of the contract is no longer in existence. Mutual mistake. Mutual and common mistakes are similar in one important aspect. They both involve a mistake of both parties. But whereas both parties make the same mistake in a common mistake, in mutual mistake they make different mistakes. In this case, both parties misunderstand each other. In this situation, the parties are not in consensus ad idem. In other words, they do not have one mind. In this case, the real legal question posed is one of offer and acceptance. Has there been a real correspondence of offer and acceptance? In other words, have the parties reached an agreement or not? And next type of mistake is unilateral mistake. In a unilateral mistake, as the name implies, only one party is mistaken. For example, A with full knowledge offers to sell an imitation of a Toyota Corolla carburetor to B. B accepts the offer, believing that the carburetor to be a genuine original Japanese made by carburetor. A knows of B's mistake concerning the transactions, therefore only B is actually operating under mistake. On the part is mistaken party, the test is subjective as where what the law is usually concerned with is his state of mind, his actual belief and intention. The court will concern itself in what reasonable man his position would have been thought or believed. Thus, the three types of mistakes are common mistake, mutual mistake, and unilateral mistake. Thank you.